We'll discuss the Islamic way of formation of contracts. After having this session, you will be able to understand the meaning of akad, that is in Arabic, and in English we call it as contract in terms of Islamic commercial law. And we will see the requirement of a valid and unenforceable contract. Let's start our discussion with a contract. Contract is, of course, is a binding agreement, is to tie at least between two parties, and it is like one party is the offerer and the other party is the offeree, the party who's making a contract, like intend to make a contract to another party. Contract is defined in modern law as an agreement between two or more persons that create an obligation to do or not to do a particular thing. Let's see the basic component of a contract is almost the same as in English law, English contract. We have a contract must have an offer, acceptance. We have offerer and one is offeree. There should be an object for it, and there should be a consideration price for it, and it should be always in compliance with the Sharia principles. One by one, if we see what is the component, an offer is the statement of intention expressed by one of the parties inviting the other party to accept this proposal. Same way, if we go for acceptance, when you are given an offer, of course there is a set way of telling that how you can accept the offer, when acceptance will take place. Just telling information and is not leading to any acceptance. Then when both parties will agree on the way that the offer is conveyed and acceptance has been made, then it can lead to a contract. At least two parties must be represented in a contract, because unilateral contract and bilateral contracts are prevalent. Parties can be individual, it can be a group, it can be between two companies, two individuals, it can be at least in two parties. As a mandatory, of course, if you're a kid of 7 years, you don't know about yourself, you are not mentally mature, and you are not in a legal capacity to make a contract. So in terms of your physical and intellectual maturity, you should be having a right age to make the contracts. And any Muslim party can conclude a contract with a Muslim and a non-Muslim party. So contracts can be between Muslims to Muslim, Muslim to non-Muslims. This is logical. In terms of object of the contract, the object should be lawful. You cannot make a contract which is not prohibited. Object of a contract refer to the subject matter that relates to the contract. Subject matter possibly can be an asset, service, money, rights or receivables. Same principle of Sharia will follow that you cannot make contract to sell wine, pornography and other things which is prohibited in Islam. Same way we cannot make contract for such other things.